Hey everyone, welcome back to the channel. Today's video is a special one because I finally get to cover one of my favorite judges to watch, Judge Flair. Just yesterday, he had a sovereign citizen in his courtroom, and let's just say he was more than prepared to set the record straight. Let's jump right into it.
My name on the docket when what I assumed was my date.
So your name is Christopher Gray, is that correct?
I'm the trustee for the account.
I'm gonna call you Christopher Gray because that's what we're looking for.
It's easy to see why Judge Flasher is a favorite. He's direct, straightforward, and doesn't sugarcoat anything. Right now, he's dealing with a defendant determined to represent himself, even though it's clear he's not prepared for the challenge.
This is the City of Detroit versus Christopher Gray. Case number SP 1357945, counts 1, 2, and 3. SP 1191985, counts 1 and counts 2. SP 1629749, counts 1 and counts 2. SP 1267865, counts 1, 2, and 3. And appearance for the record, please.
Sheriff Harris, on behalf of Mr. Gray, please state your name for the record.
Mr. Gray is appearing. I'm here as a special appearance. Mr. Gray is appearing at pro se.
Okay, Mr. Gray.
Okay, strike that appearance. Thank you.
State your name, Mr. Gray, for the record, please.
By special appearance, I'm here to appear for Christopher Lamar Gray.
All right. Today is the date and time set for a show cause. Mr. Gray, you missed the court date, sir.
I apologize, Your Honor. I made every attempt to get in. I didn't see my name on the docket when what I assumed was my date. So I don't know how I lost track of that. I do apologize, Your Honor. And
okay. All right. So your name is Christopher Gray. Is that correct?
My name.
That's what you just. Wait a minute. Let me just say what you just said. Let me just say what you just said. I didn't see my name on the docket.
I'm the trustee for the account. So for that,
I'm gonna call you Christopher Gray because that's what we're looking for.
He's told to handle his other issues first, then come back for a Faretta hearing, a proceeding that basically acts as a check to make sure he's actually capable of representing himself in court.
And then I'm gonna enter a not guilty plea on your behalf. I'm gonna give you a $0 bond.
Okay. Objection, Your Honor. I would like for the record, I reserve my right not to be compelled to perform on any contract, commercial agreement that I didn't enter knowingly, voluntarily, intentionally, and I furthermore do not accept any liability or compelled or otherwise for any contracts that I did not know that I became a part of because of a license or anything else, Your Honor. So I object, and for the record, the state can't be named a party in this suit. I asked that I put a motion before the court. I didn't get a ruling on that motion. I asked the court rule on my motion.
What is your motion? I haven't seen any motions. What is your motion?
I have a motion to dismiss, motion to strike.
And what is the basis for that?
The basis of that is there is no corpus delicti. The three components there are not those three components. There's only one of the three components here. Okay. The occurrence of loss of injury, that's not here. Whatever happened legally to cause or illegally to cause that loss, that's not here either. So of the three things, the third thing would be me being named. That's here, but the other things aren't here.
Okay.
So
is that all?
Yes, yes, Your Honor.
Okay, your motion is denied, Mr. Gray. All right, now I'm going to set this matter for a jury trial again. Let's see if we can get one quicker. Say that again?
You want to know he ever had a jury trial?
Yeah, he had a jury trial since July the 5th, but now it's not been set anymore, right? Let's get a date if we can get a date quicker than that.
Mm,
And for the record, I did not receive anything. Did you get the name? No, we don't need to check right now. I don't have anything in the file. We're gonna check the mail to see if did you mail that motion in, Mr. Gray?
That motion, one moment, Your Honor.
The motion is denied anyway, but I just want to make sure that we didn't miss anything here. Ms. Mathis, you can check the email to see if Mr. Gray filed any motion.
okay.
Again, Your Honor, I object. Article 3, Section 2, Clause 2 says that because the state has been named, in cases that the state is named, then in those cases involving ambassadors, public ministers, councils, and those in which the state has been named, those fall under the original jurisdiction of the Supreme Court. So that is my objection, and I put that on the record that if the state is being named, which the city of Detroit would be the state, then this matter doesn't fall in your jurisdiction, it falls in the Supreme Court.
Things are about to get interesting. And the one scenario a sovereign citizen dreads most is exactly this. A judge openly laughing at them and admitting he's been looking forward to the showdown.
All right. Well, you can put that in a motion or whatever you want to do, but I don't interpret the law that way, and your objection is noted for the record.
Well, I object to you ruling on. I object to you putting in a defense on my behalf. I didn't request that. I didn't put
a defense on your behalf.
You put in a not guilty, and I didn't plead that. So that's.
So you want to plead? You have two options. You have two options. You want to plead guilty, not guilty, or you want to stand mute. Three options. What do you want to do?
I stand mute.
All right, stand mute. And based on that standing mute, I'm going to enter a not guilty plea on your behalf. All right.
I object to the entering of a plea on my behalf, Your Honor.
Objection is noted on the record.
Thank you.
Well, I'm checking.
All right, let's pass the matter. I'm going to get another jury trial date, Mr. Gray, and we'll get you out of here. Next time you miss, sir, it's going to be a cash bond on you. I'll let you know that.
Understood.
This is like what they said.
Appreciate your patience, Your Honor.
Let's go back on the record for Mr. Christopher Gray. Mr. Gray, I'm going to give you a jury trial date of May the 27th, 2025 at 9 a.m. Okay.
Your Honor,
let's say 8:30.
Your Honor, I think I have in Third Circuit Court a pending case.
All right. Well, what do you have in Third Circuit?
Issue with Land Bank.
You don't have a choice. You come to in person at 8:30. You've already missed the day. You don't have a choice. You have to figure it out.
Okay.
In person, sir.
Will do.
All right. Have a great day.
Thank you.
Judge Fleer didn't hold back. He told the defendant that if he insists on traveling, he's free to walk anywhere he likes, just not in a car or behind the wheel. That's a sharp blow from the bench. And honestly, it's classic Judge Fleer.
Those were all the matters I had the opportunity to speak to at the moment. I could do a breakout room with two folks. I will highlight for the court's attention that Mr. Leonard Blatt is present in the courtroom. I briefly conversed with Mr. Blatt, and he is confident in his desire and decision to move forward today without the assistance of counsel of my office. But just highlighting for the court's attention that he's present in the courtroom, Mr. Leonard Blatt.
Okay. Is number 2 on the 2:30 calendar. Mr. Leonard Blatt, would you like to come forward? Sir, so are you Leonard Saber Blatt?
Yes.
Okay, excellent. And did you have a chance, so you're here today for an arraignment. And the purpose, did you have a chance to speak with the public defender about your rights or what an arraignment means?
I declined to speak with him.
Okay.
Can I ask who you are?
Yes, so I am a pro tem judge. So I am pro tem Judge July Simpson, and I'm here. So I am the judge, the gentleman that was just here, Mr. Stashevsky. He was the public defender, and over here is Mr. Clark. He's the prosecutor representing the state.
Yesterday, I went to get the oaths of office and bonding information on all the judges of the court, but I didn't get yours because you weren't on the website as one of the judges. Do you have an oath of office on file?
So I am a pro tem or a part-time judge.
Mhm.
And so there's a variety of those judges who work to fill in for the regular judges. I have taken an oath of office. I don't know where they store those.
At the assessor's office.
So that's, I was sworn in by the chief judge, but do you have, are you prepared to go forward today?
I don't even know I haven't seen the criminal complaint.
Okay, are we able to assist with that?
I believe we can. If I send it to Madam Clerk, could we potentially get it printed out?
So what's our printer situation? Are we still? Oh, you are good to go. Oh, fantastic. Yeah, if you could print out Mr. Blatt's paperwork.
Actually, it's just a citation. I believe the court may have that on file. However, if you don't, I can once again just send it over. Yeah, I can send that over.
Well, what we're going to do is I'm going to get those printed out for you. Why don't you take a moment to look over them? The purpose of today is just to make sure that you understand the charges against you and the rights that you have, including your right to public counsel if you qualify for it. I would strongly urge you to speak with Mr. Stashevsky. He's here today and he can advise you of your rights. I could advise you, but in case you have questions, that's your opportunity to speak with someone for purposes of today to better understand what we're doing here today.
I don't speak to the public defender because public defenders have advised me to perjure myself in court.
And that moment perfectly shows why representing yourself is such a bad idea. People often think they know what's best for themselves, but that built-in belief creates a bias that clouds judgment and makes it nearly impossible to mount a clear defense.
And I suppose you've noticed I didn't stand when you came into the courtroom. It's nothing against you personally. I don't know you, but the U.S. Supreme Court has held that physical gestures are a form of speech, and standing is a sign of respect for the court. And I have no respect for Washington courts. There's too much corruption, unprofessionalism, and arbitrary behavior. So I don't speak with public defenders because they've advised me to perjure myself in that. In the state of Washington, if you're a man accused of anything by a woman, you're presumed guilty until proven guilty. Whereas in jurisdictions where they go by the rule of law, you're presumed innocent until proven guilty. And if you're falsely accused, for example, of domestic violence, if you actually committed the crime, you can bail out of court. And as long as you don't contact the other person, you won't go back to jail. But if you're falsely accused, I don't think I have the court's intention. If you're falsely accused, you cannot bail out because the court notifies your false accuser that you're released, and that gives her a blank check to have you arrested again. And every few weeks, the public defender comes to the jail cell and gives you the good news that you can be released as long as you perjure yourself that you committed the crime. All you have to do is sign the paper and a no contact order will be issued. And I told these people, I can't certify under penalty of perjury that I committed the crime because I didn't. And the public defenders will tell you, yes, but I know you're not guilty, but all the guys get out this way. Just sign and you can go home. When you're trying to make a decision whether to plead guilty or not, you need to know how long you're going to stay in jail. But in the state of Washington, there's no longer a speedy trial right. In the court rules, now the courts can extend your stay in jail by 5 days at a time, indefinitely.
So, sir, what we're going to do at this point is I'll say for the record that we have some disagreements about the law. We have some agreements.
I have no disagreements about the law. I like the law. My problem is that the judges of the Washington courts don't obey the law.
So, sir, what I'm going to do is I'm going to give you a chance to review the documents before you. I'm going to take a break until there are some other matters ready, and that'll give you some time to review those documents, and then I'll come back onto the bench and we'll proceed from there.
Okay, I don't know if I'm recorded on the record as saying I have no problem with the law. I pay good money to the legislatures in Olympia to pass laws for my benefit.
I'd like to say he understands, but honestly, it's hard to tell. No matter how firmly Judge Fleur drives the point home, it just isn't sinking in for him.
Problem is, judges, I'm not talking about you, I don't know you, but judges in the state of Washington are free to disobey the law and flout the law. And it's like an endemic culture of corruption in the state of Washington. It's not only in the courts, it's in the law enforcement. I used to work for the Seattle Police Department, specifically the SPOG, Seattle Police Officers Guild, which is the police union. And they had me going out every day picking up checks from businesses. And these businesses were paying money to have advertising space in a publication the police were supposed to be printing. But it was a fraud. It was white-collar crime that the police were committing. And people were telling me, hey, I'm not going to pay you this year because the publication has never been published and I haven't seen it. So I would go back to headquarters and say, listen, I'm getting complaints from people that we're committing fraud, but we're the police. I keep telling them we're the police. We don't commit crimes. We fight crimes. Can I have a copy of the publication we're printing so I can show them? Well, look, we're out of copies. Well, can you tell me where they're distributed so I can pick them up and show them? Look, we pay you, right? We pay you to go pick up these checks, so why don't you just be quiet? Well, it's embarrassing when people accuse me of being part of a criminal activity. And so at this point, the police started leaving the phone booths, their panels, just surrounding me, threatening to beat me up if I told anyone.
I'm just going to take a moment. I want to express that to the extent that you've had negative interactions with our judicial system, that I am, personally appalled by that, and I and hope that that's not, the system that we are working under. I believe in our judicial system, otherwise I wouldn't be here today. Again, the purpose of today is an arraignment to ensure that you understand the charges that have been brought against you. We went ahead and printed a copy off for you to review. You've declined to speak with the public defender. So at this point, I'm going to give you some time to review the documents that we've printed out for you. Make sure that you understand that. I'm going to take a break from the bench until there's some other matters ready, and then I'll come back and we'll take up some other matters, including yours.
Okay, and I need some information about your official bond. Where is it filed and in what amount?
So let's, like I said, I'm going to take a break. Please go ahead and take a moment to review the documents, and then I'll come back and we'll readdress this matter.
Okay. I'm charged with driving with a suspended driver's license.
Sir, I'm going to take a break, and then when there are some other matters ready, I'm going to take your matter up again, including yours.
Okay.
Thank you.
I have not been served a criminal complaint, and Court Rule 2.1 requires a criminal complaint unless there's an exception. Has the prosecutor claimed any exception to the requirement of a criminal complaint?
Your Honor, the state will just note that that in the state of Washington, a law enforcement agency can indeed file a direct citation with the court, and the prosecution can go off of that.
That is correct, but Court Rule 2.1 B, subsection B, requires that the citation be signed. And What I've been handed is a citation and notice that is unsigned.
So,
Further, excuse me, also, it hasn't been timely filed with the court, so I move to dismiss the case.
I note your motion. Your motion is denied. These are matters they have been put on the record. They're matters that you can raise later. What we're here for today is an arraignment. So we're just going to go through the arraignment process, and then you can go through. And so what I'm going to do first is...
The prosecutor hasn't moved to to deny my motion. He hasn't responded. You're supposed to be neutral, right? It's supposed to be an adversarial process. And the prosecutor, we don't know what his position is.
At last, we see a judge lay it out in the plainest terms possible. If you walk away and nothing happens, then maybe the court has no power over you. But if you end up arrested and sitting in jail, that's proof enough the court does, in fact, have jurisdiction.